It began as a quiet Saturday morning in the gated community of Oak Ridge Estates. Dr. Alina Martinez, a longtime resident and retired appellate judge, was walking her dog along a tree-lined path that ran adjacent to the community clubhouse, a route she'd taken for over a decade. Moments later, she found herself surrounded by two private security officers hired by the Homeowners Association, HOA, who accused her of trespassing on restricted HOA property. Despite calmly identifying herself as a homeowner and presenting her key fob and ID, the guards insisted she leave immediately or face arrest. When she refused to be intimidated, they called local law enforcement. What the HOA didn't know, and what would soon become the center of a legal firestorm, was that Dr. Martinez wasn't just any homeowner. She was a former state appellate judge with deep expertise in civil procedure, property law, and administrative governance. More importantly, she understood precisely how, and how far, an HOA's authority could legally extend. The core of the conflict lay in a recent, poorly communicated HOA policy change. Unbeknownst to many residents, the board had quietly reclassified the walking path as private HOA operational space during a virtual meeting with minimal notice. The justification: alleged maintenance concerns and liability risks. However, no signage had been posted, no official notices mailed, and no grandfathering clause applied to long-standing usage patterns. Under most state laws, particularly in jurisdictions like California, Florida, and Texas, where HOAs are common, the association's authority is derived from its recorded covenants, conditions, and restrictions, CC and RS, and must comply with both state statutes and constitutional due process principles. Arbitrary reclassification of commonly used areas without proper notice or homeowner input often violates these frameworks. Moreover, calling law enforcement to arrest a documented homeowner for trespassing on their own community's shared property is legally dubious at best and potentially actionable at worst. When police arrived, they initially treated the matter as a standard civil dispute, but the HOA president, emboldened by past compliance from other residents, insisted on pressing charges. That's when Dr. Martinez calmly produced her judicial credentials, not to assert privilege, but to clarify the legal reality. She was not only a lawful resident, but someone who had spent decades interpreting the very laws the HOA was now flouting. Dr. Martinez's status as a judge didn't grant her immunity from the law, but it did equip her with unique tools to challenge the HOA's overreach. While sitting judges typically recuse themselves from cases involving personal interest, retired judges retain full legal rights as citizens and can pursue civil remedies like any other homeowner. More critically, her expertise allowed her to act swiftly and decisively. Within 48 hours, she filed a temporary restraining order, TRO, in county court, seeking to halt enforcement of the unauthorized path closure, compel the HOA to restore access pending a full hearing, demand disclosure of meeting minutes and voting records related to the policy change. She also sent a formal cease and desist letter to the HOA board, citing violations of the state's Open Meeting Act, which often applies to HOAs, and potential breaches of fiduciary duty. Because HOAs are quasi-governmental entities in many legal interpretations, their actions can be subject to judicial review, especially when they infringe on property rights or due process. Crucially, Dr. Martinez emphasized that she wasn't seeking special treatment. She framed her legal action as a defense of all homeowners' rights against arbitrary governance. "This isn't about me being a judge," she later told a local newspaper. "It's about whether an HOA can redefine your property rights without your knowledge or consent." The fallout was swift. The county sheriff's office declined to pursue trespassing charges once they reviewed property records and the HOA's lack of proper notice. The HOA's insurance carrier launched an internal review, concerned about liability exposure. Several board members resigned under pressure from fellow homeowners who feared rising legal fees and potential decertification of the HOA. In court, the judge assigned to the case, unrelated to Dr. Martinez, granted the TRO, noting the HOA's failure to follow its own bylaws and state-mandated procedures. a settlement was eventually reached. The path was reopened, the policy rescinded, and the HOA agreed to implement transparent voting protocols and mandatory notice periods for future rule changes. For Dr. Martinez, the episode was a stark reminder of how easily power can be abused, even in suburban neighborhoods. For the HOA, it became a costly lesson in humility and legal compliance. This incident underscores a growing tension in American residential life, the expanding power of HOAs versus the fundamental rights of individual property owners. While HOAs can enhance community standards and property values, they operate with limited oversight. Many function like mini-governments, levying fines, restricting speech, and controlling land use, but without the checks and balances of elected public bodies. The case also highlights the importance of legal literacy among homeowners. Dr. Martinez's ability to navigate the system effectively wasn't due to her title alone, but to her understanding of procedural law, property rights, and civil remedies. Ordinary residents may not have such resources, which is why many states are now considering legislation to increase HOA transparency and limit punitive enforcement powers. Ethically, the episode raises questions about the culture of compliance that HOAs sometimes foster. When boards act unilaterally or punitively, especially against long-standing residents, they risk eroding trust and inviting legal backlash. Authority without accountability is not governance, it's overreach. In the end, the story of the judge and the HOA serves as both a cautionary tale and a call to action. For HOAs to govern fairly and transparently, and for homeowners to know their rights, and when necessary, defend them.